Hey, Dustin, just state your name for the record, please.
Dustin Duncan.
All right, Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his name? There's a bond by.
Yeah, no, I see it. I got it. Don't worry. Is it 25? Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do that?
To consuming alcohol.
This isn't a mistest, it's a pattern. The judge doesn't ease into it. She goes straight to the heart of the issue. Dustin admits to drinking a twisted tea on September 13th, then alcohol again on August 30th. Then there are the missed tests scattered in between. What initially sounded like technical errors or scheduling problems begins to unravel under questioning. The judge leans on the pattern. The missed tests always seem to surround drinking incidents. You're playing with the testing, she says, making it clear she sees a strategy. Missing a test doesn't prove sobriety. It avoids detection. When asked how many times he's actually consumed alcohol while on bond, Dustin quietly admits 6 or 7. That number changes everything. This is no longer a slip. It's no longer a relapse contained to one bad night. It's repeated conduct while under court supervision. Fully aware of the stakes, the courtroom atmosphere tightens as the realization settles in. The judge isn't being misled by paperwork gaps or technical excuses. She views the missed tests not as coincidences, but as deliberate attempts to mask drinking. What Dustin framed as isolated missteps now appears to the court as a consistent effort to manipulate accountability.
The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date.
But
I mean, then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
You wrote Pickett?
I understand all of that, but my other problem is that given the other sort of missed test, I mean, what about you say the twisted tea on the 13th, what about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Vision. Can I speak?
I just said that, but you're welcome to say it if you'd like to.
No, I didn't. I started talking. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume.
Meetings aren't enough anymore. Dustin tries to regain control of the narrative. He explains that he had been sober for 4 years before falling back into alcohol. He says he has contacted his sponsor. He has reached out to Home of New Vision. He openly identifies himself as an alcoholic and insists he wants help. There is no denial about the addiction, only promises that he's taking steps to fix it. But the judge listens carefully and responds with blunt clarity. You just are continuing to consume alcohol. The tone shifts from discussion to diagnosis. In the judge's view, good intentions and phone calls have not stopped the behavior. She tells him plainly that outpatient efforts and voluntary meetings are not containing the problem. You need inpatient treatment, she states, emphasizing structure over promises. The courtroom mood changes from frustration to concern. This is no longer framed purely as disobedience. It's framed as someone who cannot manage sobriety on his own. The judge makes it clear that willpower hasn't worked, warnings haven't worked, supervision hasn't worked. If he cannot control access to alcohol in the community, then a controlled environment may be the only path forward. The message is unmistakable. Help is necessary, but it must be intensive and immediate.
You're drinking.
Yes, I
So
was.
I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7. Maybe
Yeah.
8. I had 2 missed tests. I was in the hospital, but I did. Yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. And you really, quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether pending getting into it?
This isn't just drinking, it's dangerous. The prosecution then adds a layer that escalates everything. During one of the alcohol-related incidents, Dustin wasn't merely intoxicated in private. According to the report, he was walking into active traffic while holding a knife, attempting to confront vehicles, try and provoke altercations. Officers arriving on scene allegedly encountered continued erratic behavior. The courtroom energy shifts dramatically. This is no longer a discussion about sobriety compliance. It's about public safety, intoxicated, armed, in the middle of traffic. The scenario paints a picture not only of self-destructive behavior, but of potential harm to strangers. The judge now weighs more than relapse statistics. She considers risk to the community. The defense's argument for continued release grows heavier under these facts. A person drinking privately is one concern. A person drinking while engaging in volatile conduct with a weapon in public space is another. The underlying question becomes unavoidable. If he is released again and drinks again, what happens next? The gravity of the situation deepens as the courtroom absorbs the implication that this pattern could escalate.
Inpatient treatment facility?
It's the reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the sober link sitting on the nightstand table or the couch side table.
People have some concerns if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment. if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's bonded.
The consequences catch up. Defense counsel proposes a scram tether as a compromise, a monitoring device that would track alcohol consumption and theoretically deter further violations. The argument suggests that the physical presence of a tether might serve as a constant reminder to seek help instead of alcohol. But the judge is not persuaded. A monitoring device records behavior. It does not prevent it. The court has already seen multiple violations, mistests, and admissions of repeated drinking. Add to that the public safety concerns described by the prosecution, and the balance tips decisively. The judge sets the next court date for September 30th, 2025, but before closing the hearing, she makes the ruling that defines the moment. Bond revoked. Custody ordered. There is no dramatic outburst, no raised voice, only a firm conclusion that prior opportunities did not produce change. The system provided supervision. It issued warnings. It allowed continued release despite violations. But when drinking persisted and risk escalated, the consequences followed. The hearing ends not in chaos, but in inevitability, a reminder that repeated defiance under court supervision eventually narrows the court's options to one.